This is a very interesting issue. I've really never run across something like this before, where they really have just out at the outset said, "Hey, man, if you blow and you're under, we're letting you go home," which is essentially what's happening here, right?
Yes, Judge.
Do you have any case law that says that it's okay to say that?
We have case law that says that the case that he used is overturned.
Judge, and we also have Sandoval v. State, which is from May of 2000 from the Court of Appeals of Texas, and it does.
You're saying May of 2000. When was this case?
I think that one's pretty old.
Oh, this is 95. Okay.
And it's
So
from
what case do you have? Can I
Sandoval.
see a copy?
Yep, you can keep
Oh,
that.
I think
You
I
have-
actually, Judge, may I? hand
No,
you-
no.
Okay.
They're talking.
Yeah, all right.
So Sandoval is almost the same thing as, or, I forgot the last name, but
It's the same thing.
I already know your position.
so.
I'm trying to get theirs.
It states the same thing. And the officer in this case with the facts stated, if you blow under, you can go home. And the Court of Appeals held that the court did not abuse their discretion by letting in the breath test, that it was statutorily, it was outside the statute outside the statute requirements of the DIC reading, but that it didn't
A court
Directly.
found that was not.
abuse of discretion from the trial court. Yes, Judge. For Sandoval.
Okay, so but they let it in.
Yes, Judge.
Right. But is there something that says if it's let out, it's an abuse of discretion?
That, no, it's just case by case basis at this point.
Can I see it?
Yes.
Okay. Okay. So, have you seen the cases that they cited? Okay,
I know these cases. May I point something out to you?
sure.
Was that Navarro that you just read?
I think I'm looking at your Finian. I don't think it's on point. I mean, this is just whether this guy was more afraid about getting stuck by a needle, and that's why he wanted to blow as opposed to,
100%.
whereas this one's more on point where I think it go either way.
It's 100% on point. And then what I wanted to point out to you was, I believe that was Sandoval that you were just reading.
Yes, Sandoval.
Okay, so in the in the Sandoval case, the court said the only case we have found,
Right.
they'd found concerning this very specific issue, the validity of consent given the hearing consequences of passing and failing a breath test, is State v. Sandoval. So they recognize that Sandoval is still good case law. They keep saying that Erdman overruled this case, and that's simply not true. This is still good case law, and I might also add Sandoval is in the Court of Appeals of Texas of Austin, and the case that I cited to you is the 14th Court of Appeals here in Houston, Texas.
Response?
Judge, nothing from defense. From the state. It is really just
Yeah, I
something to consider for the court.
I'm ready to rule. I think it's totally coercive. Absolutely. I mean, there's just no, I've never seen something like it, statement that, so I'm going to get locked up regardless, right? If you do breathe and you blow under, I'll take you home. If you do blow over on breath, then you're getting locked up. All right, I'll blow. I mean, really. If you blow under, quote unquote, I'm taking you home. If you blow over, you're getting booked in. If you do blood, you're getting booked in regardless, because blood takes 3 weeks, a month to come back. Yeah, I think it's totally, yeah. All right, I'm going to grant your motion as far as the breath.
Thank you, Your Honor.
Okay.
And Your Honor, just to kind of maybe make this faster tomorrow, the state has also, we kind of touched on the motion in limine. And one of my motions in limine was to keep any testimony of the horizontal gaze nystagmus, the eye test, out of evidence because it was improperly performed twice. Once, the HGN that was given might as well have stood for here goes nothing, because that's kind of what it looked like. And then the second time, the horizontal gaze nystagmus test was just murdered.
We agreed to leave it out already.
So, okay, but I just wanted to clear that up for the record.
So just, admonish your officer accordingly, hey, please don't get into this, and then that'll make it smooth and then, yeah,
Absolutely.
okay. Anything else?
No.
No,
Okay.
Judge, and we also came, just for the record, we did come to an agreement as to where the body cam would be redacted.
Okay.
And the portion that is redacted includes some statements that were on defense's motion for limine. So it becomes moot at that point.
Got it. Just make sure you watch beforehand so that you're okay with everything, so that when we do watch, it goes smooth and we don't,
Yeah, if I can get a copy of the one that they're going to offer into evidence today, I can
Do you
review it
have,
tomorrow.
do you have one
I
here?
I do not have a redacted portion of the body worn camera right now, but I can get it to you by the end of today.
Yeah, that's
I
fine.
can send it to
That's
you.
fine. I'm good with that.
All right, guys.
Thank you.
Thanks.
See you tomorrow. Counsel.
That person about an opt-out matter.
Yeah.
Cause number is.
Hi, Mr. Newley.
Good afternoon, Judge. So very busy today.
Almost done.
Cause number 25.
And here's the legal twist. The judge admits technically this isn't a probation violation. So even though the man was a drug dealer, the system's hands are tied in a way. It's not about what he did before, but what he's done since. Still, listen closely, the judge's tone shifts here. You can hear the frustration as she weighs justice, mercy, and the law all at once.
541895. That's Gascon.
Okay.
And Mr. Gascon is in the courtroom today. He needs to travel for his job and he's on the call-in, random call-in.
That
I
him over
spoke-
there?
That is him.
Okay.
I
So
spoke,
there's no travel restriction. If he gets called in to take a test while he's gone, he's going to have to go to a Quest Diagnostics, wherever he's located. Again, they're all over the country. I don't want Punka City Labs. It's got to be Quest Diagnostics, so it's ASCLD certified. We know that it's a legitimate lab. He gets the results to you guys, you get it to them, and then we're
Thank you, Judge.
thank you.
Say it again?
You want me to have like cases that are over 150 days after those are turned?
No, 180. 180.
Oh, 180.
Yeah, just, if it's at 150, just ask, is discovery complete? Because if discovery is not complete at 150, then we got a problem.
You could probably.
Whose plea is this? Do you know?
This is Bernardo Fleischer, the one that was like last minute, and then we set for tomorrow. We're just waiting on Plaza. He's in custody.
Okay,
And she should be on the way.
So I got the panel outside, so I'll give him 5 minutes just to use the restroom.
okay. If you want to go ahead and let the lawyers know in the trial case, that there should be in one of the witness rooms that the panel is here.
Okay.
See if they're ready,
Okay. Yes, sir.
please.
What time do you usually can be taking a break? I'm sure I'll be back.
I don't know, let's see I don't know if we're even gonna go because,
Oh.
so let me see
Okay.
if they can work something out. I don't know. Hi.
Yeah, good morning. Raquel Williams. It's a DWI. We just need to get medical records released. They're going to file the motion. I just wanted to approach to see if we can make note of it so that it can be done in between time instead of when we come back for that release.
You mean,
There's,
have medical records ready to give to them?
Yes, and we just need to file the motion.
Okay, so go ahead, file it, I'll sign it. As soon as you file it, I'll sign it. So it's old though, it's 184 days old. Do you have an offer?
we're supposed to be trying to get PTI on it. She did a TRAS the last.
So first apply, don't just get the TRAS because, there's a lot of changes that have been made. So I've seen more denials now. So
She's already done the T-Rash.
Oh, she's already done it.
Yeah, I had her do it when she was here last time because her parents had been waived, so
Tell me, is blood test?
it should be blood from, it was a hospital visit, so, yeah, there was blood. It was like a point one.
What is it? What are the results?
7, I believe.
Adults.
There's a part 1 7.
I'm curious to see whether she's approved or if she needs a medication packet.
It was 10125.
What is it?
125.
Okay, so it's not.
I did have, mitigation. I need to scan everything and send it over. It
Accident?
was an accident. She ran into the back of a tow vehicle,
I think
but still an accident.
still gonna need
Right.
it. It's just, you know, they're gonna want insurance and all that stuff.
Right.
How much time do you want?
I can't hear you, Judge.
Shh. How much time do you want?
A couple weeks is fine with me. I don't need.
So
I'll be able
what I
to
would,
get
so can you get the records to her today? Please file the motion. I'll send it now. That way we're ready with that. And then in the interim, we'll give you 2 to 3 weeks.
Okay.
But the next setting, if you can have everything turned in, and then that way we'll wait for a response whether approved or denied. And I mean,
And then I have a question for you, Judge. Her license is valid now. And can she drive? She wanted me to ask for permission. Last time you told her to ask before doing anything. She's working, but Dad is taking her back and
I would
forth.
ask is just make sure that she has liability insurance. Right. Make sure she has car insurance. If she has car insurance, then I'm okay
Dad
with
told
it.
me he
As long
put
as
her
the
on.
license is clear and she has insurance, I'm okay with it.
Just want to document it. It's fine.
Alicia, on Raquel Williams, we ordered no driving. Can you confirm with her now? Ms. Moore? Can you confirm with her now? Does she have insurance now?
Dad replaced her on, I confirmed with him. He was here last setting with her and they were ready to confirm it then.
So they have car insurance?
It's not, let me find out if he actually, because I told him that last time, judge is gonna want to know you have it already.
As long as she has car insurance, I'll amend the conditions to allow her to drive.
Okay, okay.
Yeah. And then after that, if she does, let Felicia know, and then we'll amend the conditions to allow her to drive, and then just get a reset with Billy, and then, yeah. Mr. Butler, are you able to work it out or no?
Work out some of the.
Just the case in general or no?
So they agree that my issue is, good and valid on that first case. Yeah. And we can talk about it if you want to.
No, I get it.
Yes, sir. And we have to show you from the years, we can take you right through that second.
I don't think, look, have you seen what he's talking about?
Yes, and I just spoke with,
And is it as in the motion, has he say, have you seen this?
That is a transcript.
the
Okay.
facts of the motion are as Lisa it's, yes.
What do you think?
I actually just spoke to Alex and he said that case was recently overruled by it.
Yes, Judge, the Airman case was overruled by the Court of Appeals, the Criminal Court of Appeals in 2012 by a case.
No, this is Serrano.
They cited the Airman case, the underlying.
You talking about Simon? It didn't overrule Erdman.
They state,
No, it didn't.
and I would like to, we can read it together. I would like to share it with the court. And
Last I checked, a Court of Appeals out of the Sixth Circuit or something does not overrule the Court of Criminal.
this is the Court of Criminal Appeals, Finnan.
I'm sorry?
Finnan is out of the Court of Criminal Appeals.
Okay, so tell me what it's, let's do this.
One second. So. One.
Obviously, we'll give you time to look at it so you can.
Yeah, no, it's still up to you. I've read fine.
And I would like to share it with you. So it says the rules developed by Airman's progeny are contrary to the fundamental rules to determine whether consent was rendered voluntary. Importantly, these rules, like the analysis of Airman himself, overlook the fact that the voluntariness of consent must be analyzed based on the totality of circumstances.
That's
And,
what Sandoval says, my
Now,
friend.
hold on, let him finish. Let him finish.
and no statement, whether it refers to the consequences of refusing a blood test, the consequences of passing or failing a blood test, or otherwise should be analyzed in isolation because its impact can only be understood when surrounding circumstances are accounted for. In other words, allowing any statement by itself to control the voluntariness analysis contradicts the basic rule that voluntariness must be determined based on case-specific consideration.
Sure, of course.
And then they explicitly say Therefore, because of its flawed reasoning and the flawed case law that results from it, we overrule Erdman, which is what that Serrano case relies upon, is Erdman.
So Judge, so Erdman, just, by the way, didn't overrule Erdman in its entirety. So what they're saying is the construct. So let's think about what Erdman was. In Erdman, the officer read a statutory warning, okay, that said that if the person didn't give a breath test, that they were going to get blood. That's not coercive. That was reading the statute. So if you read the case that I cited, Serrano, and then there's Navarro after that, open law.
So, and I want to give you time to look at everything, right? But I mean, this is like right on point with this.
100%.
Right on point, right? So
And
if Erdman is right on point with this, then okay. But if it's not right on point with this, then it's,
And Judge, then there's Sandoval as well. One of your sister courts just 2 days ago also ruled in an exact situation like this, where an officer gave the improper admonishments that, hey, you know, if you give a breath test, I'm going to take you home. And
okay,
that's what
so
was said.
I think that we're getting way ahead of each other. So let's, first off, we're not on the record, are we? Yeah, we need to get there. So, yeah, we're getting way ahead of ourselves. So, all right, Ramona, you ready? Guys, we're going on the record. If you want to talk, go outside, please. Yeah. Yeah, as long as you confirm. Okay, I trust you. All right. We are on the record in cause number 2505428. State of Texas versus Stephen Garcia. Today is February 11th, 2025. It's approximately 9:49 in the morning, a.m. Guys, I'd like you to please announce yourselves for purposes of the record. State first.
Diana Davila for the state of Texas.
Mackenzie Watson for the state of Texas.
Jim Butler for Stephen Garcia.
Okay, so I think that we were getting ahead of ourselves here. We started without even going on the record. So today is day for trial. Both parties have announced ready?
Yes,
This should.
Okay.
we're ready.
So what we have here is just kind of a brief introduction and where defense has challenged the breath test in this case and its admissibility thereof. You guys have reviewed everything outside, correct?
Yeah, Judge, so just for the record, the state and the defense sat down in the back room and we kind of went through some of the motions. We went through the motion that I just filed. And then we also began going through the motions in limine. So, and then of course, we brought this motion to keep the breath test out, basically because the officer gave language that was outside statutory language that they are supposed to give when they're offering somebody a breath test. And we're alleging that he basically tells my client, hey, look, if you blow, and if you blow under the legal limit, I'm going to put you in the car and take you home. And the evidence will show that my client relied upon that. In fact, at one point, when the officer is cuffing him and stuffing him, he's like, well, wait a minute, you said I was going to get to give a breath test, because he believed that he was under the limit, wasn't going to register, over 0.08, and was relying on the fact that if he gave that test, all of this ended and the officer would cut him loose and take him home. And then, of course, after that, and after the officer said, no, we got to go downtown because our machine's downtown, he again repeated that and said, look, if you blow under, we're going to get in the car and I'm going to take you home. And again, repeated that. And my client relied upon that and thought that that would happen. Of course, that's not what's going to happen. And Judge, and based on your experience, it's also possible that he could go down there and blow under the legal limit and the DA could still accept charges for DWI. So that was impermissible language that should not have been given in this case.
Response?
And one other thing,
And if
Judge.
you're not ready yet, it's okay, because I know that we're
Okay,
kind
I was
of,
just giving her the opportunity of what she wants to do. We did review the facts on the motion. We agree that the facts stated were as reflected on defense's motion. However, we do disagree with the case law given to support the fact that just because of the statements given by the officer, the body cam should be, the breath test should be excluded. The underlying case law has negative treatment by the Texas Criminal Court of Appeals, and there is other cases within the same jurisdiction that have different treatment. However, we have come to the agreement that because what the case given by defense, once it goes upon appeal, it is only reviewed for abuse of discretion, and the case that overruled or gave negative treatment to Erdman says the same thing. Basically, it is the totality of the circumstances, and if you're able to relate a certain link between what was specifically said to the officer and what the defendant believed to be true, and if that gave him a specific idea of what was going to happen or moved him towards the direction of the breath test versus the blood test. So I think we're both in agreement that the only way to resolve it is by you reviewing what was exactly said by the officer on the timestamps given and using the court's discretion to come to the conclusion.
Let me ask you this. Have you had a chance to see whether Serrano, the case that he provided, I mean, it's right on point. Have you
It has not been
seen?
overruled, just so you know. And I think just to give you a little more information. So I agreed with that treatment of Erdman. I thought that it was not that great of a case because in Erdman, look, you had a officer that was doing nothing more than reading the statutory language. I mean, he wasn't even saying like, hey, go down there and give a sample. And if you are under, I'm going to take you home, which is like dangling candy in front of a baby, and that's the kind of thing that the law wants to prevent. The law says, here's the statute that you read. Navarro, which is another case that's cited among the cases that we're talking about.
I understand. Is there something that negates Serrano? Is there a case that says, hey, saying something like this is okay?
It would just be Finan, which is the Texas Criminal Appeals case that just states that it was not a breach of discretion to keep it out and that it would have to be a totality of the circumstances.
Okay.
And we 100% agree with that, and we know that. And so, Judge, the other thing that I wanted to say without going into Erdman is the Navarro case talks about, it's very good, and it talks about what the statutory language should be and why it is there and what it informs the person. If you give a test and if it's over the limit, here are the consequences of that. If you refuse the test, here are the consequences with your driver's license. And then, if you refuse, we can get a warrant to get your blood. That's all they're supposed to give them. And then they sit back and then the person either agrees or they don't agree. You can't sit there and then start enticing the person by telling them things to get them to change their mind. And clearly you're going to see that on the video. This officer says these extrajudicial statements. Hey, if we go down there, if you blow over or under, pardon me, we're going to get in the car and I'm going to take you home. Now, if you blow over, you're going to be arrested. But if you ask for a blood test, then you're also going to go to jail and, it could be a week or however long.
This is the emotional core of the case, a defense attorney painting a redemption arc. But here's the thing, Texas courts don't just look at how you behave on probation. They look at why you're there in the first place. Selling over 200 grams isn't minor, it's considered major drug distribution. So while his story of change is powerful, the question is it enough to outweigh his past?
On before that blood comes back. So he's thinking, man, I better go down there and give a breath because I'm going to go home. And you just can't be saying stuff like that.
We have a panel here ready to go. So I don't want to keep them waiting. They've already been waiting for, 30 minutes. So how do you guys want to proceed?
Judge, if it's okay with you,
Are you ready to argue the merits of this? Because what I was going to suggest is that we go ahead, pick the jury, and then we can just start and finish argument with this.
Well,
right after
the only thing that
I don't want to keep them waiting.
No, I understand that. The only thing is that that kind of does change the voir dire a bit, doesn't it?
If you want to exclude the breath test part of your voir dire, then I guess it can be talked about. It's not totally excluded, even if it gets excluded, because we can't force them into specific facts that there is no breath
Of
test.
course.
So I think we.
I guess we're ready to roll. And then we can.
I just want to keep the waiting. Let's get it started, and then right after we get done with the paneling, then we can,
Sure.
and then that'll give you more time to look, to see if there's something else that you want to look at as far as case law or whatnot.
And Judge, we'll print a copy for the court of the 2 outstanding case law that we have.
For sure. Okay. Any lawyers want to approach real quick before we bring the jury in?
Yeah.
Are you want to do your plea?
Yes, Judge.
Okay. Yeah, let's do it. All right, guys, if you're in the middle, we're going to ask you to please move over to the side because we're going to have a panel coming in and they're going to sit in the middle, please. So if you don't mind, please move it to the side.
I'm gonna sign.
Yes, he's coming.
Huh?
I was hoping you could finish briefly.
Yes, no, we'll get it done today. Hi, talk to me. Yes.
Portraying on Victor Navarro. This is an assault with a family member. His mom is here, who is the complaining witness as well. There's a protective order. I am requesting that the court lift the protective order. She is the only person to take care of him. I spoke with her this morning.
Spoke about a couple days ago.
No, this is new. This one is new for me.
It's on document.
It is on docket today.
Is he in jail?
He is in custody, so I'm asking for 2 things today. One, a PR bond. He does not have any other violent criminal history. Also, no other cases pending. I'm not sure.
Let's read this. Shh, everybody keep it down, please. Hey,
Yes, Mom.
Alex, I'm going to read this. You ready? This is on Navarro. Okay, let me read this to you. This is why the magistrate did not give him a warrant, because I don't know.
Right, okay.
No adult criminal history, Harris County. No charges since 1999. This case, defendant is complaining witness's son. Complaining witness reports defendant got angry when he was asked to help move a shelf. Then later in the day, pushed complaining witness down to the floor and began punching her repeatedly, causing pain and scratches to her face. Defendant has been diagnosed with mental health issues. Complaining witness wants to press charges because he needs to learn his lesson and could possibly kill her one day if she does not take action. Her AFC defendant is not employed. Spanish speaker on AFC, English in court. Defendant declined PDO and appointment of counsel, but per PDO, he is 1622 consented to prior to docket allowed PDO to represent a PC. I need to talk to him. So, yeah. Yeah, let's bring him out.
Okay.
We'll talk. All right, come on. Bless, you ready?
Yes, Your Honor.
Okay, come on.
Yes.
You are Alberto Lopez.
Yes.
Mr. Lopez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. Is it being reduced to a first? It looks like it's being reduced to a first. What you must understand that this is still 2. So if you ever pick up another DWI, you will be facing a felony charge of a 3rd-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. If I were you, I would never get into a car and drive if you have even had a sip of alcohol because you were playing, you're taking a humongous risk. Do you understand?
Yes.
You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty, there is no changing this. It will go on your record. It'll be there forever. How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm going to find you guilty and we'll send it to you to the agreement. I'm going to suspend your ability to drive for 1 year. Do not drive until you get a license. Good luck to you, sir.
Hey, Judge, and Your Honor, I was appointed to this case, and I don't believe my client's financial status has changed since he's been in custody. But we asked the court to waive the DPS fee. Thank you, Judge.
Come on up. Good morning, Mr. Navarro. Do you speak English, sir? If you're going to play games, it's just not going to go well, man. You know, really.
Respectful, please.
Your lawyer's asking me to give you a PR bond, but if I know now that you're going to give me issues, I'm just not going to do it, you know? My soul, the only thing I want to do is protect the public. Do you understand? So your lawyer's asking me to, you know, give you a PR bond, but what I need to know is if we let you out, is there going to be a problem with mom?
Judge, I'm also going to do jail release instructions. So if we could do a jail release order so that he can go to the Harris Center. Mom is right here. Miss Francisco? The main concern, Judge, he needs to get on his medication. So I spoke with Mom. If we can do a PR bond, I can do a jail release order for him to go to the Harris Center.
Lost is still here. Do you speak English, man?
Yes.
Oh, wonderful. Okay. Are you okay if he goes back to your house?
I want, if you just wanted to get him like getaway, that's what I want, you know.
So what,
I wish I could just find a place where they could at least a month to make sure he is on the medications and stuff like that.
well, I can make it a condition of his bond that he's supposed to take his medication. And if he doesn't, then,
That's what makes him start acting out because I can't force it anything.
well, I am now making it a condition of your bond that, Mr. Navarro, if you want to be out on a PR bond, you have to take your medication. If you don't, then no more PR bond. Do you understand? I'm not asking for much.
He's not very, he doesn't even know how to talk to people, you know. His mind is like sometimes not there, you know what I mean? He understands certain things, but I just have a problem with him. You know, he takes it out on me, not no one else, you know what I'm saying? But I don't want to get him spraying on him because he's gonna be on the street homeless, you know, and I can't let my son live in the street.
I got it. I understand. And I'm okay with it. Mr. Navarro, do you want me to let you out?
Out to my home house, yeah, whatever.
You have to understand though, I want you to take the medication. Do you understand? If you do not, mom is going to call us, let us know, and then you're going to be right back here with us. So I want you to understand the only thing I'm asking you to do is take your medicine and be nice to mom. It's not hard. When you take the medication, good things happen. Can you do that for me?
Yeah.
You promise? I'm serious. So mom, I'm going to give you, we're going to give her your phone number. So if you have any problems, call her, let her know. She'll talk to me and we'll take care of business for you.
Tell him that if the cops show up, he's not gonna get out, he's gonna stay here.
Come on, everybody.
Yeah, you say that, Junior, because we're here in front of the judge.
Okay.
You have to take life serious, Junior.
Mm-hmm.
That hurts good if you like this.
We don't want to keep you.
Okay, that sounds good, yeah, but still, I can't.
Next time you're getting out.
Okay, I know.
Better.
Okay, Mr. Navarro, make me proud, huh? Just keep taking the medication. Good things happen, all right? Okay,
Thank you,
yeah,
Judge.
I'll grant it for you.
Thank you.
Okay, ma'am, any problems, just let us know. We're here to help you out, okay? Really.
It can't, she in the hospital, like, for a
What we do
month.
is we can, we can do jail release where we'll take him to the,
Yeah.
no.
I will go to my holistic department and we will find resources for that. But I did explain to her that the Harris Center would just take him from jail, do the evaluation. They can't keep him there.
Problem is that at the Harris Center, we can't hold him. We can't force him to stay. If he wants to leave, he can leave. We just can't.
I know.
That's why we will be in contact.
But they have resources at the defender's office to help you out. So whatever you guys need. And then just stay in touch with us if you,
I'm trying to get out of the journey, but I don't
We will
like
help
more.
you. We can help you do that.
we'll help. Okay.
Thank you, Judge.
Good luck, man.
Thank you.
That was for Navarro. Any bond conditions for?
No weapons and take medication.
Yes, Judge.
The state wants to approach on an extradition case. I oppose.
Your Honor, we're asking to approach on Nelson Morrow, call number 255-0421,
255.
0421.
Okay.
Your Honor, he is wanted out of Multnomah County, Oregon on 5 counts of sexual abuse. He's got a $1,250,000 bond. The demanding jurisdiction has requested a 3-day reset due to staffing issues.
Have you had a reset before?
I'm sorry?
Have you had one before?
A reset? No, Your Honor.
They haven't. I have no object.
Okay. I'll grant it for you, but that's it.
Thank you, Judge.
Okay. All right. Thanks, sir. Okay, are you ready? All right, bring it on. Rock and roll. Guys, if you want to sit in the, Ramona, are you going to stay there? You don't want to go to where you normally go? Okay. All accounted for? All right, everybody, please be seated. Good morning, everybody, on this wet and rainy day. Good morning. Oh, thank you so very much for coming. You should really pat yourselves on the back. Really, I know that the weather's kind of crummy. I know that it's hot, humid, that
Okay, hold on, did you catch that? The judge already gave this man probation even while multiple serious drug cases were still pending. That's highly unusual. Normally, judges wait until everything is resolved. So you can bet Judge Fleischer or whoever's presiding is watching closely to see if that trust was misplaced.
most people don't want to be here. Look, I'd rather be at home too, but I really, your sense of civic duty, just, it's amazing. And I really, really thank you. And I love that we have such a great cross section of the community here today. That's what makes, criminal justice possible. A lot of other countries, a lot of other places don't have this. And that's what makes our system so great because, without you guys, we just can't function. My name is David Fleischer. I'm the judge here in County Criminal Court at Law Number 5. It is one of 16 misdemeanor courts here in Harris County. So just to give you a brief rundown, I don't know what you know, so I'm going to go from the top. So what are we? We are one of the misdemeanor courts. Well, what's a misdemeanor? Okay, well, in Texas, there are two types of offenses. There are felonies, and then there are misdemeanors. Does anybody know what the difference is? Anyone? Yes, so to speak. It's based on the amount of time. So a year and above, you're looking at a felony in jail. And below that, a year and under, you're looking at a misdemeanor. Now, within those two categories, there's always subcategories just because of there's so many different types of crimes, they have to subcategorize it. I'm not going to get into the felony because we don't deal with that here. I like to sleep at night and those just, yeah. Anyways, so now within misdemeanors, there's three types. There's A, B, and C. Class C misdemeanor types are the type where, let's say you get pulled over for speeding. you get pulled over for no insurance, or, believe it or not, there's a Class C assault, disorderly conduct, whatever it may be. Depending on where you are in our city, because it's so big, you may go to municipal court, which a lot of people know about here on Lubbock. If you're out in Katy, you may go to a justice of the peace court. If you're out in Webster, or if you're out in that area, Clear Lake, you may go to one of the justice of the peace out there. So depending on where the occurrence happened is where you might go. Here in our criminal courts, our 16 county criminal courts, we deal with only B and A misdemeanors. B are punishable, anything punishable by up to 180 days and or a $2,000 fine. And Class A misdemeanors are those that are punishable by up to a year in jail and or a $4,000 fine. So we only have those two types that we deal with here in our county criminal court at law. Like I said, we have 16 of us because of the amount of people that we have here. And I will tell you now, percentage-wise, I would say 7, maybe 8% of the people that are called upon to come for jury service actually show. It is such an abysmal rate that's why I really congratulate you on coming, because we really sorely need more people to show up. Because like I said, without you guys, we just can't function. So what we have here, we have 2 sets of lawyers that I'd like to introduce you to. We have the state's lawyers, and then we have defense. State, would you please identify yourselves? Does anybody recognize them? Okay, defense.
Good morning, I'm Jim Butler. Pleased to meet you all.
Does anybody recognize Mr. Butler? Okay, guys, please. So what we have now is we're here for a trial. I don't think that anybody disagrees with the law in general. What they disagree with is perhaps how things happened, whether someone is innocent, guilty, and that's why we have you here. We are really not asking you to split the atom. We're not asking you to do Pythagorean's theorem. All we are asking you to do is use common sense. What's going to happen is a fact pattern is going to be given to you guys. All we want you to do is listen and make a judgment call. I have told this time and again to all the jurors that come here. You really know when you listen to someone in your heart, in your gut, whether that person knows what they're talking about or whether they're from outer space. That's all we are asking you to do. Any kind of preconceived notions, any kind of past things, we're going to ask you, or they're going to ask you, whether you have something that has happened in your life that would render you unable to be able to sit for this type of case. Okay, we're here on a DWI. And so they're going to ask you whether there's something that has happened. But at the end of the day, all we want you to do is listen and make a judgment call. Because you are the people that will listen, look at the evidence, and make a decision at the end of the day. So what we're going to do today is we will start with voir dire today, what we're doing, and then we will start with testimony tomorrow, and I anticipate that we will also conclude tomorrow. Is there anyone here that can't be here tomorrow? Anyone? Okay, you are 1, 2, 6. Okay. Is there anyone else that can't be here tomorrow for any reason? The last thing we want is we want you to get impaneled, and that for some reason you can't be here tomorrow. It's the worst. And so that's why it's okay. We just want to know, is there something why you've got plane tickets, a doctor's appointment, one reason or the other that you can't be here tomorrow? Okay, so. Now, it's not just because you want to have lunch with someone. It's you got a serious doctor's appointment or, plane tickets, not just because you've got lunch with, So I got 5, 6, and 32. Is that it? Okay. Is there anyone here that is not comfortable with English? Doesn't speak English, speaks something different? Okay. And what number are you, ma'am? Okay. Anyone else? Anyone else? Okay. So what I'm going to do now is I'm going to turn it over to the lawyers. I'm going to give them each, about 25 minutes to speak to you, get to know you. I know it's a short amount of time to get to know someone, but the idea is that the only thing that we're looking for are people who really have an open mind and are fair. Literally just listen and then make a judgment call at the end. That's all we would like. Okay, are you ready? Okay, floor is yours.